Hi everyone, I'm outside the Supreme Court of Singapore. I just received the judgment on section 377A that I filed on behalf of my client Dr. Roy Tan to get a declaration from the court that section 377A is unconstitutional. We just received the judgment and the court has ruled that 377A is not, section 377A is not unconstitutional and that it does not violate the equality provision of the Constitution, namely Article 12. It's very disappointing because this law, which is a relic of the colonial past, which is highly discriminatory and highly demeaning, and has been struck down in many Commonwealth countries in the recent past. The last decision was, from what I hear, is from India and some other countries as well. Now, this challenge, by way of background, I would say has been a long march for myself, acting on behalf of two plaintiffs, challenging this discriminatory legislation. The first time when 377A was challenged, I was before this court in 2010, that was 10 years ago, on behalf of Tan Eng Hong, who challenged it in 2010. And subsequently in 2012, the Court of Appeal of Singapore ruled that 377A may be potentially unconstitutional, and therefore it gave standing to all the gay community, all members of the gay community, to stand to challenge this legislation. And then the subsequent challenges have taken place, the last being the recent challenges that were filed by three plaintiffs, including my client. I would say that the court's decision is certainly something that I will take on board with my legal team, which comprises of legal experts locally and internationally. And I will take on board the decision of the court, which I am waiting to receive the full decision in a moment. And we received short notes from the judge on his brief grounds of decision earlier this afternoon. And I would say that what is indeed very shocking for me from this judgment is to note that despite the prevailing scientific evidence that has been presented in the court, that the court still say that this scientific evidence can go either way. And we know that it is only the males who are targeted on this unconstitutional legislation. And I will not comment much on the fact that it is in terms of the legal arguments. I think this is something that many of you could already read online through the various articles that have been posted and discussed thus far. Now, 2010, this challenge started. It had a momentary victory in 2012. It went through a phase and it has come before this court after the Indian decision, after the Indian decision that struck down, that in India they struck down 377A as unconstitutional. And now we are on the next phase of discussing on the prospects of appealing this decision. There's no firm decision yet on this issue, but I will certainly inform you and of my client's decision if he chooses to appeal and take this fight to the Court of Appeal. I would again say that despite all that the former Attorney Generals have come, Justice V.K. Raja, as he then was, the ex-Chief Justice, Mr. Chan Keong, Mr. Walter Woon, and all these Attorney Generals and Mr. Tommy Koh, who spoke on this issue as well, saying that this law is not only archaic, that it is unconstitutional. The court has unfortunately ruled it otherwise. I will now go back to office, wait for the call from the court to collect the full judgment, study it carefully, and discuss with my experts, and we will then decide the next course of action. On that note, I wish you all the best, and I will just say that we will not give up. Thank you very much, everyone, for your wonderful support all these years.